All rise.
The Kosovo Specialist Chambers is now in session.
Be seated. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case CBC 2020-06, the Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Selimini, Yakub Krasniqi.
Thank you. For the record, I note that Mr. Thaçi and Mr. Krasniqi are attending today's hearing via video link. Mr. Veseli and Salimi are present in court. Today we will start hearing the evidence of prosecution witness for W04446. Madam Court Usher, please bring the witness in. Good morning, witness.
Yes, sir.
Good morning.
Mr. Witness, can you hear me?
Oh,
Yes.
Take pursuant to Rule 141, subparagraph 2 of our rules. Please read the document aloud.
interjection.
Conscious of the significance of my testimony and my legal responsibility, I solemnly declare that I will tell the truth, the whole truth, and nothing but the truth, and that I shall not withhold anything which has come to my knowledge.
Scourge of Holiday.
Thank you.
Witness, today we will start your testimony, which is expected to last approximately 4 hours. As you may know, the prosecution will ask you questions first. Once they are finished, the defense has the right to ask you questions, and then members of the panel might also ask questions of you. The prosecution estimate for your examination by them is 1 hour. The defense estimates that it will need 3 hours and 15 minutes. As regards each estimate, we hope that counsel will be judicious in the use of their time. The panel may also allow re-examination by the prosecution if conditions are met. Witness, please try to answer the questions clearly with short sentences. If you don't understand a question, feel free to ask counsel to repeat the question or tell them you don't understand and they will clarify it. Also, please try to indicate the basis of your knowledge of facts and circumstances that you will be asked about. In the event you are asked by the SBO to attest to some corrections made regarding your statements, you are reminded to confirm on the record that the written statement, as corrected by the list of corrections, accurately reflects your declaration. Please also speak into the microphone and wait 5 seconds before answering a question, and then speak at a slow pace to allow the prosecutors to catch up. While you're giving evidence in this court, you are not allowed to discuss with anyone the content of your testimony outside of the courtroom. If any person asks you questions outside this court about your testimony, please let us know. Please stop talking if I ask you to do so, and also stop talking if you see me raise my hand. These indications mean that I need to give you an instruction. If you feel the need to take breaks, please let us know and an accommodation will be made. We begin with the prosecution's questions of you. They are seated on your left. Please give them your attention. Madam Prosecutor, you have the floor.
Thank you, Your Honor, and good morning. Good morning, witness. My name is Vega Iodice, and today I will be asking you questions on behalf of the SPO. As explained during our last meeting, rather than asking you questions about every relevant issue you may have information about, it may be possible to admit some of your prior statements containing such information into evidence. There are a number of procedural steps to follow in order to do so. Before turning to these, I will first establish your identity. Your Honor, if we could please move into private session to obtain some of the identifying details of the witness.
For the protection of the witness, please take us into private session, Madam Court Officer.
Your Honor, we're in private session.
Thank you. Go ahead.
Your Honors, we are now in public session.
Witness, you have given statements in the past, including to the SPO, and you were allowed to review those statements in preparation of your testimony. Today, we will seek to tender your statements into evidence. Could the court officer please bring up ERN 011022, 011029, read 2, not for public broadcast. And witness, we are now in open session, so please do not mention any of your identifying details. No, mention your name or any detail that might identify you, okay? Can we go to page...
Second, you have to answer yes or no. You can't nod your head, witness.
Yes.
Can we go to page, to the first page in English and page 5 in Albanian, which is 011026. Witness, looking at the document on your screen, do you recognize this as the statement you gave before the Special Prosecution Office of the Republic of Kosovo?
Yes.
Go to page 4 in English, that's page 011025, not for public broadcast. And if we can scroll towards the end of the page where the signature blocks are. Witness, do you recognize your signature on this document?
Yes, I do.
The court officer now bring up ERN 066675 TR 80 Part 1 Red 2. Witness, do you recall being interviewed by the SPO in 2019?
Yes.
Statements in your language last week.
Yes.
Opportunity to make corrections and clarifications to your statements.
Yes.
Actions were written down in a note and were read back to you.
Yes.
That what was read back to you in that note reflects your changes fully and accurately.
Yes, of course.
Now, if we include all the corrections and clarifications you made last week, is the information in your two statements accurate and truthful to the best of your knowledge and belief?
Yes.
The same questions today about the same events. Would your answers be the same?
Yes.
Your Honor, having fulfilled the Rule 154 criterion in accordance with decision F02117, paragraph 58 A and B, we would like to tender the statements into evidence, and with your leave, I would like to read the RN numbers.
Yes, go ahead.
The statements are ERN 011022, 011029, Red 2, 066675, TR, ET, Part 1, Red 2, 066675, TR, ET, Part 2, Red 2, and 066674, 066674 as an associated exhibit to the SPO interview, together with preparation note 1, which is ERN 120135 to 120140.
Any objection to the tender from the Thaçi defense?
No objection.
No, thank you.
Thank you.
Nothing, Your Honor.
No.
All right. ERN 011022 to 011029, RED2 is admitted. ERN 066675, TRAT, Part 1, RED2 is admitted. The prep note of 066675, TRET, Part 2, RED2. No, I'm sorry, that's not the prep note. The prep note is ERN 120135 to ERN 120140. And the associated exhibit is 066674 to 066674. Those are all admitted. You may give a number.
Thank you, Ernest. So for the first statement, 011022 to 011029 RED2 will be assigned Exhibit P 1056. Second statement, 066675 TRET Part 1 RED2, together with the Albanian version of it, will be assigned Exhibit P 1057.1. Part 2 of that same ERN will be Exhibit P 1057.2. Associate Exhibit 066674 to 066674 will be assigned Exhibit P 1058, and the preparation note 120135 to 120140 will be assigned Exhibit P 1059. And just to confirm, Your Honors, they should all be classified confidential.
Do you wish to remain confidential as far as all of the documents?
Yes, Your Honor.
All right. You may proceed.
Your Honor, on 15th of March, the SPO submitted the proposed summary for this witness, now admitted 154 statement, to the panel Defense and Victims. We have not received any objection, so with your leave, I would like to read the summary in open session.
You may proceed.
Thank you. WO4446 learned from a relative that his brother had been arrested by the KLA. When WO4446 went to look for his brother, KLA soldiers told him to speak to a KLA commander, who confirmed that WO4446 brother was there and that his case was being investigated, as the KLA believed he was a collaborator of the occupier. WO4446 and other family members went back to inquire about his brother several times. At a certain point, WO4446 understood that his brother was no longer at the KLA headquarters. He was threatened not to return. The remains of WO4446 brother were never found. Your Honor, I have a few additional questions which concern details that would identify the witness, so I would like to request to move into private session.
Your Honors, we're now in private session.
Witness, you previously stated
Your Honors, we're in public session.
Thank you. We'll take a 10-minute break.
All rise. All rise.
Be seated. You may bring the witness in, Madam Court Officer. I guess she's not the court officer.
Your Honour, if we could just go back into private session as well.
Yes, please take us back into private session for the protection of the witness.
Your Honors, we're now in private session.
Thank you. All right, witness, we will continue with Mr. Roberts' questions of you. Go ahead, Mr. Roberts.
Thank you, Your Honour. Welcome back, witness.
Theory.
That's okay.
Minutes were in public session.
We're adjourned until 11:30.
All rise. All rise.
Please be seated. Madam Court Usher, you can bring the witness back into the court. What's the time frame, Mr. Misitich?
I would say about a half an hour, 45 minutes.
Ms. Rowan, how long is your cross going to be?
Your Honour, at the moment I'm unlikely to have any questions.
About 15 minutes. About 15 minutes.
Witness, we will continue with the questions from Mr. Misitich. You have the floor, Mr. Misitich.
Thank you, Mr. President. Witness, picking up where we left off before the break,
Witness, your testimony today is completed. The court usher will escort you out of the room. Thank you for being with us and for sharing your information with us. We wish you well.
Thank you. I believe that this court is the last train to uncover some truths. And I think that if you fail to uncover them, they will remain a mystery. But I believe that you are able to uncover those truths, to uncover what happened. And those things happened. Had they not happened, I wouldn't have been sitting here as a witness. Thank you very much, and I wish you well in your work.
We're trying to figure out what to do about timing. We need to break for at least a half hour to get set up for the next witness who is going to appear via video link, and that would get us back in here with about 15 minutes, which doesn't seem to make much sense to start and stop. So we will break for lunch now, come back at 2:30, and we will be ready to proceed at that time. We're adjourned. Oh, I'm sorry, we're in public session. We're in private session. Please take us into public session.
Your Honors, we're now in public session. All rise. All rise.
Be seated. Before we start hearing evidence of prosecution, witness 4571, the panel wishes to issue two oral orders. First, the page range assigned to Exhibit P1052, which was admitted into evidence during W02475's testimony. The panel recalls that on 10 December 2023, the panel issued its Rule 154 decision, which was F01848, in which it determined at paragraph 35 and 41 that pages 024855 to 024859 of a report entitled Roma in the Kosovo Conflict with ERN 024844 to 024865 were not appropriate for admission pursuant to Rules 138 and 154, as they did not form an indispensable and inseparable part of W02475's statement. The panel noted, however, that this was without prejudice to the SBO offering these items, separately or eliciting additional evidence in relation to those pages. Yesterday, the SBO tendered these pages as part of a larger report without eliciting any additional evidence on the subject matter contained therein. The panel therefore determines that in line with its decision F01848, there is no reason for pages 024855 to 024859 to be admitted at this time. The panel therefore orders the registry to remove those two pages from P01052 so that the admitted exhibit reflects only the pages that were found appropriate for admission in F01848. This includes the panel's first oral order. Regarding the objection to the use by judges of documents disclosed to the defense pursuant to 102. Paragraph 3, the panel rules as follows. As is apparent from Rule 127 sub 3 and from the panel's order on the conduct of proceedings, the panel can ask any question it considers relevant to the fulfillment of its responsibilities, in particular to establish the truth. Secondly, the rules on which Mr. Misitich sought to rely are binding not on the panel but on SBO. They are rules of disclosure that regulate inter-parties communication of information and have no application to the panel directly. The panel is not the custodian of the records of either party but can decide to make use of documents that are available to it as a result of the disclosure process. The panel is, in that regard, no better placed than the defense and has access to the same material. Thirdly, the panel notes that Rule 102 sub 3 places the onus upon the defense to seek disclosure of any document of which they have received notice from the SBO in application of that rule. That regime was intended to benefit the defense by allowing the defense, rather than the SBO, to decide what could be relevant to its case. Lastly, consistent with the ruling of the Court of Appeals panel, the panel notes that judicial questioning is not subject to any limitation of substance or form, but requires the panel to conduct its questioning fairly. The panel is satisfied that fairness was guaranteed in this case. First, the documents had been disclosed to the defense in disclosure packages 325, 337, 384/388, and was available to the defense, which by its own accounts it was able to locate. Secondly, the document, when used, was placed on the screen during questioning so that it was visible to all. Thirdly, the defense could have asked questions about it if relevant to its case or asked for more time to review that document if necessary. Lastly, the very content of the document should have alerted the defense to its potential relevance to the witness's evidence, as it contained an account pertaining to the fate of that witness's relative about whom the witness testified. Based on the above, the panel finds that the Thaçi objection to the use of Rule 102 sub 3 as a basis for judicial questioning is without merit. However, the panel has decided to exercise its own discretion to review material which it plans to use with future witnesses. Where the panel wishes to put to the witness material from the public domain, or where it wishes to put to a witness material that was disclosed to the defense pursuant to Rule 102.3, it will endeavor to give notice of that fact to the parties prior to the commencement of questioning. This concludes the second oral order. We will now start hearing the evidence of prosecution witness 4571. And Ms. Rowan, I see you on your feet. Do you have something to bring up?
Your Honour, yes, we notified the court this morning that there was a matter of law to be raised in advance of this witness's testimony. Sure. I'll be as short as I can. Your Honour, as notified this morning, the objection relates to two documents that the SBO showed this witness in their preparation session conducted at the end of last week. For the record, the two documents in question are ERNs U0018211 to 8252, and the second document is ERN 099928 to 099955. Your Honour, the objection is twofold. The primary objection is that of want of notice, and the second objection relates to lack of compliance, again, with Rule 138. In relation to the concerns around want of notice, for clarity, Your Honour, the SPO with this witness put to him last week in their preparatory session 4 documents that they had not previously notified. This objection is confined to 2, as 2 of those documents are already exhibits in this case. In our submission, the way that these documents have been dealt with we are now straying into a situation where the defendant's right to have adequate facilities and time to prepare are being infringed upon, and also that the order and conduct of proceedings is no longer being properly respected by the SPO, by the manner in which these documents are being used and preparation sessions are being conducted. In filing 1226, the conduct of proceedings clearly states that the SPO is required to notify parties in advance of the documents which they intend to put to a witness. Now, that serves a very clear purpose, which is to allow the defence to identify any issues, to take instructions from their client, to make any investigations that they see fit. And that rule is in place for a reason. But unfortunately, that process has now, for all intents and purposes, broke down in this trial.
Can I interrupt you for a moment?
Of course.
Have you taken this concern to the SBO and talked to them about it as required by Rule 42 or 43 of our rules on conduct of the proceeding?
Well, the difficulty, Your Honour, is the short answer is no, but the reason is the preparation.
Then why didn't you?
Well, the difficulty, Your Honour, is we received yesterday the preparation session notes for this witness in the middle of the afternoon when we were in court. We were then provided with them to review at the end of the court day at 4:30, when the SPO, I assume, will have gone home and all parties would be working out of hours. We then were busy yesterday evening.
So you're just assuming they went home. You didn't really go and try to find out.
I didn't go to try and find out. No, that's not something that the defence took steps to do. We emailed the SPO, though, to clarify whether or not they intended to use the documents in question with the witness. We sent that email last night to engage in communication. We're asking for the SPO not to be permitted to use both of these documents with this witness.
Are you asking for time to further consider these 2 documents?
Our submission is that we've had insufficient time to deal with them.
Are you asking for more time to do that?
Would Your Honour allow me to turn my back for a moment? Would Your Honour allow me to turn my back for a moment, please? Thank you. Your Honour, the application this afternoon is not for more time at this stage. What we are raising is a general difficulty in how we are being expected to deal with documents disclosed in this fashion, that it's putting undue pressure and unnecessary pressure on defence teams.
Yeah, thank you, Your Honour.
I'm sorry, let me hear from the prosecution. My mic was turned off.
No problem. We take an issue with the lack of notice. Both of the items were disclosed in July 2021 under Rule 1021B. The defense has been notified about the documents and what the witness said about them as it's all recorded in a preparation note 2, distributed on 18th of March, that's right. And in fact, the defense only sent an email yesterday about one of the 4 documents at 10 p.m. We take issue with the lack of notice. We notified the defense as soon as we could, which was yesterday, the content of the preparation note, and it was all recorded in the note as to what the witness said.
Your Honour, the difficulty is this witness's preparation session concluded on Friday afternoon, and for no justifiable reason, the SPO sat on that preparation note until yesterday afternoon. They are 3 full days the defence could have put to good use in preparing this information and these documents. We were deprived of that for no reason. The SPO, in relation to this witness, filed its list of documents for use in October of last year. That filing relates to filing 1828. So some 5 months ago, the SPO indicated the documents that it intended to use. So the defence was in a position to prepare for this witness on the basis, and we should be able, on a good faith basis, to rely upon the filings given by the SPO, and that when they say in October of 23, these are the documents that we intend to use, we should be entitled to rely upon that on a good faith basis, and not be ambushed the evening before a witness is due to come. With documents particularly of this nature, Your Honour, the SPO knows that these are the types of documents that again and again cause the defence issue, cause objection, and cause concern. These are handwritten notebooks that again appear in vacuums like we've seen repeatedly with these lists. And to expect the defence to deal with a 42-page handwritten note disclosed and identified to us the night before a witness is due to testify is insufficient, and it's an abuse of the preparatory session process.
But you've had this document for a long time, right?
It's been in the disclosure. It hasn't been notified for use with this witness. It has been notified for use in this block.
You have a certain obligation when you get a document noted under 1023. You have an obligation to decide, is this possible for us to need this? It's kind of difficult to come in at this point and say, oh, we didn't know about that.
Well, Your Honour, considering the vastness of the evidential base of this trial, the defence has to be given some deference in the capacity that we have to review all evidence. And again, it's not our obligation to foresee what case the SPO is going to bring. The SPO has an obligation to notify us of that case. We, on a good faith basis, have the right to rely upon their submissions in their filings and have adequate time to prepare properly, not be dealing with situations such as this, where 42-page handwritten documents of unknown origin are given to us the day before a witness is due to testify. It's simply not acceptable.
Is there some reason you waited from Friday until yesterday to submit this?
May I respond, Your Honour? Can I briefly just address a few points that we were finalizing the note. It was, as you know, the preparation was dealt remotely, and it took us a long time to finalize it.
That's not a great answer either. Go ahead.
No, but what I wanted to say about the lack of notice also is that the document in question, the 42-page document, is referenced in footnote in the pretrial brief, and it relates specifically to the events that the witness in question will testify about. This witness also, we were not expecting the witness to be called as early in the schedule. In fact, it was due to the defense cutting their cross-examination substantively. So we were not anticipated to start until Wednesday, and the email was sent on Monday at 12, which was yesterday. The session was concluded on Friday evening. So this is the SPO submission on this, on lack of notice.
I understand your request. Well, I don't need to hear anymore. I understand what you're bringing up. I understand it. I'm directing the prosecution to do a better job of getting you advance warning for a document coming in, although this is a fine line because it came in Friday late and was given to you noon yesterday. Number two, you did not follow our rules on 43 to take this up with the prosecution. It's taking valuable time for the trial away from us. It's not what we need to do right now. You did not ask for any further time to examine this, so your objection is overruled. But I will direct the prosecution to please take these issues more seriously. It should have been notified. They should have been notified on Friday if you interviewed him on Friday. It takes 15 minutes extra to do that, and it should have been done. Thank you.
Your Honour, the objection was two-pronged, the second prong of that being that neither of these documents satisfy the Rule 138 criteria.
That's premature. That's premature at this time. We have to see what happens in the hearing. I don't even know if they're going to use these documents.
We've been informed that they will use the substantive first document cited.
We'll wait and see on that. Go ahead.
Very well.
Please bring the witness into the courtroom.
Your Honors, for the record, present in the transmission room are witness W04571 and myself, court officer.
Good afternoon, witness. I'm going to read the text of a solemn.
Good afternoon.
Ask you to repeat the text after you've heard me make my statement. Do you understand that?
Yes.
This is the statement. Conscious of the significance of my testimony,
Yes.
conscious of the conscious
Yes.
testimony. Please repeat that.
Conscious of the significance of my testimony
Responsibility
and my legal responsibility,
I declare
I solemnly declare
all the truth
that I will tell the truth, the whole truth, and nothing but the truth.
will not withhold anything
And I shall not withhold anything which has come to my knowledge.
You may be seated.
Thank you.
Can we get the camera up there so we can see the witness? There we go. Witness, today we will start your testimony, which is expected to last approximately 6.5 hours. As you may know, the prosecution will ask you questions first. Once they are finished, the defense has the right to ask questions of you. Members of the panel might also ask questions of you. The prosecution estimate for your examination is 1 hour. The defense estimates that it will need 5.5 hours. As regard each estimate, we hope that counsel will be judicious in the use of their time. The panel may allow redirect examination if conditions for it are met. Please try to answer the questions clearly with short sentences. If you don't understand a question, feel free to ask counsel to repeat the question or tell them you don't understand and they will clarify. Also, please try to indicate the basis of your knowledge of facts and circumstances that you will be asked about. In the event you are asked by the SBO to attest to some corrections made regarding your statements, you are reminded to confirm on the record that the written statement, as corrected by the list of corrections, accurately reflects your declaration. Please also speak into the microphone and wait 5 seconds before answering a question, and speak at a slow pace for the interpreters to catch up. While you are giving evidence in this court, you are not allowed to discuss with anyone the content of your testimony outside of the courtroom. If any person asks you questions outside of this court about your testimony, please let us know. Please stop talking if I ask you to do so, and also stop talking if you see me raise my hand. These indications mean that I need to give you an instruction. If you feel the need to take a break, please make an indication and an accommodation will be made. The panel understands that the SBO has hard copies of your prior witness statements for you to reference during your testimony in case of need. If you cannot recall something and therefore wish to consult these documents to refresh your memory, Please notify the panel before doing so. I repeat that this should only be done in the event that you need to make that reference because you cannot recall. You should not read directly from these documents. We begin first with the prosecution's questions for you. They will begin at this time. Madam Prosecutor, you may proceed.
Thank you, Your Honor. Good afternoon, witness. We have met before, but I will
Good afternoon.
again. I am Dunya Tabi on behalf of the SPO, and I will be asking you questions for the next hour or so. Before I ask the presiding judge to move into private session to obtain information to establish your identity, I will note that, as I explained to you during your preparation session last week, rather than asking you questions about every relevant issue you may have information about, it is possible to admit some of your prior statements containing such information into evidence. And in order to do so, there are a number of procedural steps to follow, which I will turn after establishing first your identity. Your Honor, we will need to move into private session.
Please take us to private session, Madam Court Officer.
Your Honor, we're now in private session.
Thank you. May we proceed?
Thank you, Your Honor. Mr. Witness, can you please state your first and last name?
Your Honor, we're now in public session.
Thank you, Your Honor. The item I will be asking to be shown today are not for public broadcast unless I specifically said so. Witness, I'd like to show you a document. Court officer, could you please show the witness 075468-TR part-ET part 1, read 2, and side by side with the Albanian version, which is 075468-TR-AT part 1, revised, read 2. And this document refers to meeting with the SPO in March 2020. Mr. Witness, do you recall that meeting?
I can say yes. Yes.
That meeting, correct? Thank you. And do you recall being provided with an opportunity to provide clarifications in relation to this statement last week?
Yes.
Thank you. Do you recall that you made a number of clarifications to this prior statement?
Yes.
Do you recall these clarifications and corrections being included in the note which was read back to you?
Yes.
Subject to the correction set out in the note, is the information provided in the statement I referred you to today accurate and truthful to the best of your knowledge and belief?
From what I remember, and I believe that's what happened.
Subject to the correction set out in the note, does the statement I refer you today accurately reflect what you would say if you were examined about the events recorded therein?
I have some problems with my memory. However, when I listen to what you're telling me, certain things come into my mind.
Do you remember, Mr. Witness? So you remember having reviewed your statement last week, correct? Do you remember?
Yes, Madam Prosecutor, yes, I do remember.
You made some clarifications and
Yes.
correct?
Yes.
And as I explained to you, there is this procedure whereby instead of asking questions about every aspect of your testimony contained in the statement, if you confirm that you would say the same thing today in the courtroom, if you would confirm that it would reflect accurately the events at the time, would you sorry. If I were to ask you the question today, would you answer in the same way?
We will see, but I think so, yes.
And what you said in your statement, the statement that are recording following your meeting in March 2020, you said the truth, right?
Yes, I remember, and it should be like that.
I'd like to seek admission of the prior statement and the two associate exhibits, the relevant year-end of which are set out in our 18 of March 2023 email and in Annex 1 to Prep Note 1, which is ERN 120146-120152. And we also ask to tender this note for admission.
Any objection?
None other than what we've already written in the 154 response.
No, thank you.
Nothing further, Your Honor.
No objection.
075468 TR-ET Part 1 Red 2 and the Albanian 075468 TR-AT Part 1 Red 2. plus the preparation note 120146 to 120152, and the associated exhibits are all admitted and will be assigned exhibit numbers.
Your Honor, before I proceed, I note that the statement actually has 5 parts, and which were part of the Rule 154 decision, but just to clarify, what do I assign numbers to?
I believe she only offered one, part one.
Sorry. I would like to offer for admission the 5 parts of the transcripts. So it's exactly part 1 to 5 in the English and the Albanian version.
Thank you for the correction.
Okay, so 075468 TRET Part 1 RED 2 and the corresponding Albanian transcript will be assigned Exhibit P 1060.1. 075468 TRET Part 2 and the Albanian corresponding transcript will be Exhibit P 1060.2. Part 3 with the same ERN will be Exhibit P 1060.3. Part 4 will be Exhibit P 1060.4. And Part 5 will be Exhibit P 1060.5. The 2 associated exhibits, which is listed in footnote 99 of the Rule 154 decision F1901, are ERN 078022 to 078022, which will be assigned Exhibit P 1061. Associate exhibit with ERN U0005370 to U0005370 will be ET will be assigned Exhibit P 1062, and the preparation note with ERN 120146 to 120152 will be assigned Exhibit P 1063. Thank you.
You may proceed.
Thank you, Your Honor. Your Honor, on March 15th, 2024, the SPO submitted a proposed summary of this witness is now admitted Rule 154 statement to the panel, defense and victims. We have not received any objection to the proposed summary and procedure, so with your leave, I will read the summary now in open session.
You may proceed.
In or around August 1998, WO4571, a Kosovo Albanian, was arrested by multiple KLA soldiers. WO4571 was taken by car to the local KLA headquarters. He was questioned by KLA members, including about a Koditini, and told inter alia that he had to help the KLA. He was detained with others who showed severe signs of mistreatment.
Your Honors, we're in public session.
Thank you. We'll take a 10-minute break.
All rise. All rise.
Be seated. Madam Court Officer, you can bring the witness back into the room. All right, Madam Prosecutor. Witness, the prosecution will continue with their questions.
Thank you, Your Honor. Could we move back to private session, please?
Please take us to private session, Madam Court Officer.
Your Honors, we're in private session.
May proceed.
Thank you, Your Honor. Mr. Witness, I have only 2 more pages to show you. I'll turn on this document.
So what's the relevance of the fact that the allegations in the documents are true or not, which you've just spent 3 minutes telling us about?
The relevance, Your Honour, is the only evidence that this witness can give about this document is I recognise that name. The relevance of this document can only be relevant if it is shown to be authentic. It can only be probative if it is authentically authored by the KLA. Because this witness does not know where this document came from, does not know its authorship, does not know its origin, does not know its chain of custody, he cannot speak to any of those issues. So he cannot authenticate this document in all of the ways one would traditionally expect and anticipate a witness to be able to have the capacity to authenticate a document. The reason these submissions are being made is because of the previous rulings of the panel and conduct of the prosecution. The prosecution in the past has sought to use civilian witnesses in this way to authenticate lists, paper, notebook, taken out of evidential vacuums from the evidence that we have. And they have sought to submit in the past, well, this witness is able to say that's his name on the paper, therefore he can speak to the document, therefore this document is authentic, therefore this document is admissible. Now, this document is of a different nature. This document contains far more allegations and much broader content than what we've had to date. And the reason these submissions are being made is to underline the fact that this witness is in absolutely no position to speak to the content of this document. He knows nothing of these allegations. He knows nothing of these propositions. He knows nothing of this content. Therefore, his evidence is of no value. Because his evidence is of no value and of no relevance, it cannot authenticate the document. Therefore, the document has not been shown to be authentic to the standard required by Rule 138, and therefore it's not admissible. And that is before the panel go on to consider probative value, relevance and prejudice, all of which I can address the panel on, but we're dealing with only the first limb of a 4-limb test. In my submission, the prosecution fall massively down at the first hurdle.
Your Honor, is that, just to be sure, is that the extent of the objection to the admissibility of this document?
I'm content to address Your Honour in detail in relation to prejudice, probative value and relevance in further detail, but I'm focusing on authenticity for the moment. I'm content to deal with those 3 limbs now. I'm in Your Honour's hands.
Something else you want to say before the prosecution does?
When Your Honour is coming on to consider the other factors, which is in relation to both relevance and of probative value, Your Honour is bound to consider, and I don't wish to repeat or mirror submissions made yesterday in relation to similar documents, but again we are concerned with issues of authorship, provenance, chains of custody. These documents appear, again, in a vacuum. The prejudice in relation to these documents is obvious, as His Honour Judge Mitro has already set out. There are various allegations contained in these documents. We don't know who wrote them. We cannot know who wrote them. We don't know when, where, why. And the prejudice to the defence in tackling and dealing with those objections when we cannot understand where the document originated from is an obvious and a significant prejudice. The probative value in relation to this document as a result of that absence of information is very low. So when one looks at the low probative value of the document, by comparison to the high prejudice caused to these defendants, in my submission that weighs against its admission.
So your objection is to all 4 areas of 138?
All 4 limbs.
All right, go ahead.
Thank you, Your Honor. With regard to provenance and indicia of authenticity, it's the SPO submission that the defense has not demonstrated any basis to challenge the authenticity of the document. The document was provided to the SPO by the ICTY DEMICT, and they were originally provided by the Serbian authority. The notebook contains several dated, handwritten accounts of events and names of individuals. The witness importantly recognized his name and that of several other persons.
We'll accommodate you, Mr. Witness. You be there at 10 o'clock tomorrow, and we will do our best to finish your testimony then. Thank you for being with us today. Remember not to talk with
Thank you all very much.
anyone about your testimony in court today. And if anyone tries to talk to you about your testimony, please let us know. Madam Court Officer, you may escort the witness out of the room.
I will not speak to anyone. I'm conscious about this. I heard your instructions before, and I will obey them.
That.
My greetings to all of you.
Madam Court Officer, into public session. Do you need something in private session, Madam?
No, it can be in public.
Okay.
Your Honours, we're in public session.
Yes, Ms. Rowan.
Your Honour, simply if I could invite the panel not to issue its determination in relation to the admissibility of the contested documents until all of the evidence is heard tomorrow, i.e. post cross-examination.
We'll determine that when we make our decision, all right? We
Yes.
will either postpone it and let you know, or we will issue it immediately based upon our discussions.
Yes, because of course, Your Honour, the trial panel will be best placed, having heard everything about these documents, to make a determination as to these documents' authenticity.
Thank you.
Mr. President, just on the time estimate, you can feel comfortably take that hour tomorrow away from my time. I expect to finish much shorter, so we'll be on time. Thank you.
So it looks like we will start at 10 o'clock. It seemed like a reasonable request. We'll see you all tomorrow morning at 10 o'clock, and we're adjourned.
All rise.